Hello, I'm Mike Fellows, and welcome to this edition of Other People's Pockets for August the 16th. And we just spent a week at the Western Montana Fair here in Missoula. We were upstairs in the commercial building. Got a lot of people that came by and said hello and passed out quite a bit of information to folks, and I really got a pretty good reception. Today's Billings Gazette, we find that Congress, especially Dennis Rehberg, is using his franking privileges on his re-election campaign. Seems that he spent $60,000 for printing and postage on some mailings that were sent out to a select group of Montanans, and I had the chance to look at some of these things tonight, and they certainly do. It's in green paper, but it certainly does look like a re-election thing rather than just an informational brochure that talks about things coming up in the fall of Congress. And so really that's one thing you can say, that Rehberg is not a fiscal conservative, and he does like to spend your money a little bit too freely. But tonight I want to talk about the Jury Rights Day that's coming up next month, September the 5th. It marks the anniversary of the William Penn trial in England, where he was convicted simply preaching the word of Quakerism, when the only law of England said that there wasn't no other religions besides the Church of England. And the jury thought that was a bad law, and so they, despite having been locked up without the conveniences of life, the jury still held fast, and now we do have this notion that juries can judge the law and they can vote their conscience. And even the County Attorneys Association had, at the many times we've done legislation at the state legislature, said the same things. They can do that now, but we shouldn't require the judges to talk about it. And the judges themselves, judges do what judges want to do, and so we're just trying to change it. So if you think that the government is using too heavy a hand, you think the punishment doesn't fit the crime, or you think the law is wrong, well, you can always vote to acquit without any trouble with the law or the judge, because juries have always had that right to judge the law, and they can certainly vote their conscience on issues. And we've seen that a few years back in Kalispell, particularly when a wife was involved in an abusive relationship. She didn't find any way out, and eventually on a barbecue took a knife and killed her husband. Well, the jury acquitted her. They let her off, and they figured that was the only chance she had to get out of that abusive relationship, and the jury agreed. And the county attorney up there basically said, that the jury was talking about societal norms on these things, and they agreed that she had the right to get out of the relationships, even though she did commit a crime. And so this is a tape we did 2 or 3 years back with Elio Jones, who was the executive director of the Fully Informed Jury Association. Done my telephone here in the studio, and if you have any questions, you can always go to our website at www.lp.org, or go to the Fully Informed Jury website, which is www.fija.org, and they do have a 1-800 number, 1-800-TELL-JURY, that if you want to request for information about the fully informed jury and what your rights are in the jury box and in the jury pool. Once you sit back and learn about the juries, and because I know that recently a lot of people got sent mailings from both the Justice of the Peace, and eventually you'll be called for jury duty, and it's good to know your rights. And so we'll go ahead and run some of this, and we'll talk to you later. Welcome to another edition of Other People's Pockets. My name is Mike Fellows. I am the producer of Other People's Pockets on this Wednesday's edition of Libertarians Live show. Our first show has always dealt with the topic of juries and the safeguards they provide. Tonight we have by telephone Executive Director of the Fully Informed Jury Association, Elio Jones. Hello, Elio. Thank you for being here.
Hi, Mike. It's nice to be with you this evening. Thank you for inviting me to be on your show. I'm glad we're going to get a chance to talk about Jury Rights Day, which, of course, as you know, is coming up on Friday, September the 5th.
Well, why don't we start with Jury Rights Day, and why do we have it, and what's the history behind it?
Jury Rights Day is the anniversary of the acquittal of William Penn. And most people don't know that before William Penn came to this country, he was a Quaker in England. And he was preaching the Quaker religion, a sermon about, on the Quaker faith, in London in 1670. And he was arrested because he broke a law that established the Church of England as the only legal church. And the king had made this law that said you cannot talk about or preach or print anything about another religion. You'll be breaking the law. You can only preach and talk about the religion established under and endorsed by the Church of England. Pretty harsh, right?
That is.
So he was put on trial before a judge, and he had a jury. And his jurors refused to convict him. They were locked away while they were deliberating, and they were basically told by the judge, you have to find him guilty. He broke the law. And the judge locked him in a room without food or water or toilet facilities or heat, and said, you have to find him guilty. And they refused to find him guilty. They said, the law is wrong. He didn't do anything wrong. The law is wrong. Yes. So the judge fined them. They refused to pay the fine, and they were put in prison for 9 weeks, more than 2 months. Can you imagine? Being thrown in prison for rendering a verdict based on your conscience and your own sense of right and wrong.
Well, that is pretty harsh.
It was tough. So it was appealed to the highest court in England by basically the backers of these poor jury people who have been thrown into prison. And the court, the highest court, acknowledged that trial by jurors was legal and binding. Their verdict was legal and binding, that they could not be punished for their verdicts, and that they had the right to judge the facts as well as the law. So when William Penn came to this country, and a lot of other fellows were talking about things they needed to put into the Constitution,
right,
we got from this trial both the right to practice religion, and by the way, our Constitution and our Bill of Rights doesn't say separation of church and state. It says, the state cannot establish a state religion, and they were very concerned that it might, and they didn't want it to. So they made that, and they also put in about juries many times because they had found juries to be the most powerful protection for the people against government tyranny. Isn't that interesting? Most people today think that the job of a juror and the function of a jury is to render a verdict to censure or punish one of their fellow citizens for breaking the law. But that's not what our founding fathers intended the jury to do at all. They intended the jury to protect citizens from tyrannical government, tyrannical judges, and tyrannical laws.
So you mentioned religious freedom.
Yes.
Is there any other freedoms we have from this trial by jury?
Well, in colonial America, before the Constitution was written, there was a fellow who was a printer, and his name was John Peter Zinger. And he wrote some exposés about the corruption of the royal governor in, I'm pretty sure it was New York, which was, of course, not a state at that time, but a colony. And so he wrote this article, or a series of articles, about the corruption going on in the royal governor's circle of friends in New York. I'm pretty sure it was New York. And all the things that they were doing, and the embezzlement, and how they were ignoring even their own laws, and really being pretty tyrannical and abusive of their power. And so the governor of New York took him to court and sued him for printing libel. And at that time, the truth was not considered a defense in a libel case. You simply weren't supposed to say bad things about your betters, so to speak. You weren't supposed to say bad things about the people in power.
Well, I guess you couldn't say many good things either.
Pardon?
You couldn't say many good things either. But
you really couldn't say much at all. But the judge told the jury that he has broken the law, and the fact that he printed the truth, and he proved that John Peter Zinger proved he had printed the truth. They said, that's no defense. Truth is no defense. The jury absolutely refused to find John Peter Zinger guilty of libel. And his attorney, Andrew Hamilton, not Alexander Hamilton, but a guy named Andrew Hamilton,
right,
told the jurors the story of William Penn. Remember back when William Penn was on trial in London for preaching the Quaker religion, and the jury refused to find him guilty and they were punished, but they stuck to their convictions and they voted their conscience and they won. And William Penn won and the freedom of religion won. Well, the jurors listened to what Andrew Hamilton had to say and said that they could not in good conscience find Peter Singer guilty of violating a law that was such a horrible law when truth was no defense. And so they acquitted him. And that, of course, gave us our right to free press and the protection. We have incredible protections of the press. Here are you and I talking on a form of the press today against government intrusion. And it also established truth as a defense in trials where libel was involved, or slander. Isn't that amazing?
That is, and so juries can actually...
It set these precedents for our country, yes.
So I know in today's paper we have some big headlines. I'm looking at the Missoulian, September 3, 2003. It says 3 states, death sentences tossed.
Yes.
And that's...
Yes, in Nevada, Idaho, and Montana, where the jury was not allowed to understand that the verdict they rendered would result in a death penalty, which was issued by the judge as a sentencing person. All of those must now be revisited. And these are not the only cases where jurors have been kept in the dark about what's going to happen to someone if they render a verdict. Very often, jurors are compelled, or no one is allowed. I mean, the defense attorneys are compelled not to inform the jurors of what might happen to the defendant if they find him guilty. And very often, because the government brings most criminal charges, or all criminal charges, the prosecutor and the judge, of course, both work for the government.
Right, because I know in several cases, the judge is simply not allowed certain factions of the truth, whether it's talking about the Constitution, or whether it's talking about Prop 215 in California.
Yes.
They can't use that as part of their defense.
And we'll talk about a case involving Prop 215 in California in a minute. But the jurors are not allowed to know what result their verdict will cause for the defendant, which is horrible. And so in a case that goes back some time ago, but is fairly recent, and probably most people will know about this case and these trials, when the survivors of Waco were put on trial for very minor charges, basically, but also some major charges that were put together by the federal prosecutors and brought before the federal judges. The jury simply didn't think they were guilty of these horrible things, but they thought, well, they've been brought to trial. They must have done something wrong. Maybe they did actually do some of these minor things, and so we're going to find them guilty of the least significant charges, because they obviously, if they're on trial, they must have done something wrong, which, again, that was their thinking. Isn't that horrible these days? We don't consider people on trial to be innocent until they're actually proven absolutely guilty beyond any reasonable doubt. We assume that if they're there, they've probably done something wrong. So this jury thought, well, okay, we'll find them guilty on the least count we can, and since they've already served time, they'll probably get off for time served or time served plus a couple months. But the judge was very angry with these defendants because he considered them to be people who were challenging the power of the courts and the government. And so even though the offenses for which they were found guilty by this jury were very minor, the judge made their sentences as harsh as he possibly could. And when the jurors in that case of this trial about the Waco incident, and the defendants, the survivors, I should say, who became defendants, when the jury found out what the judge had done, they were so upset that they went to the newspapers, of course. They cried. They pleaded with the judge not to do this to these people. They said, haven't they suffered enough? They haven't really done anything that wrong. Why are you doing this to them? And the judge didn't answer them except to say they need to be taught a lesson.
Well, that kind of situation happens, I think, more than often than we really hear about.
We don't hear about it in most cases because they don't get a lot of publicity because they're kind of everyday cases. This happened to be a famous case. And we were talking about Proposition 215 in California. Do you think most of our listeners know what that was?
I think a lot of them probably do. We've talked about it on a number of occasions. And
Proposition 215, of course, said that in California that people were legally allowed under doctor's supervision and a prescription, basically, to use medical marijuana to alleviate all kinds of conditions for which marijuana has been used since before marijuana was made illegal. I was talking to a fellow over in Butte. He said, my grandfather used to smoke marijuana for his glaucoma, but then they made it illegal and he couldn't use it anymore. It was really too bad.
Yep.
And people who said, you know, it really helped my arthritis pain, but I can't use it anymore. And people who said, I used to sneak marijuana cigarettes because when I was taking chemotherapy, it was the only way I could keep down any food. And it kept me alive. And now I'm afraid to use it anymore because I'm afraid the feds will come and break down my door. So California, looking at all of these, passed Proposition 215 that said there would be licensed distribution centers and people would be under physician supervision and they could use medical marijuana. There was this fellow named Ed Rosenthal who was licensed by the city of Oakland. Now remember this, he was licensed by the city of Oakland under Proposition 215.
Well, he was also deputized too, I imagine.
Pardon?
I think he was also deputized.
I think, yes, he was deputized, and he was guaranteed immunity.
That's correct.
Deputized. He was guaranteed immunity by the city of Oakland and I think the state of California. And so that he could grow plants to give to people who needed them so they didn't have to go find a dealer on a street corner, you know?
That's correct. He was an excellent gardener.
Yeah, and he was helping people, and he wasn't making tons of money off this. He's not a rich guy, and he certainly wasn't a drug lord, nor was he out, you know, hustling school-age children to, you know, here, try this and get hooked on it or anything like that. He was helping people who needed this to alleviate a lot of pain and suffering. And I don't smoke anything, by the way. But then again, thank goodness, I'm not sick. But if I became sick and if sometime I needed treatment, for instance, chemotherapy treatment, that required that I take all this medicine that would make me very sick, I had thought about this when Proposition 215 was passed, that, I can go to California. And if I do it there, I'll be a lot better off.
Right.
I can get marijuana in case I need it. And I can get it legally, you know? And
not out the black market. There are a number of...
Exactly. Not on some corner from some, you know, hoodlum who's selling it and making a ton of money because it's a, you know, very restricted market, a very restricted product that's illegal. Just like all the guys got so rich running whiskey during Prohibition. But anyway, back to Ed Rosenthal. So Ed is growing plants for all these people, and maybe for some dispensaries, I'm not quite sure. But he had like a warehouse that was a greenhouse where he was growing these plants. Now remember, he's not selling these. He's not selling these on the street corner. He's not, you know, smuggling out little packages of dope to people and making, you know, $20 on the side. He's doing this under supervision. He's licensed. He's deputized. He's doing this totally above board. The feds raided the place. They took pictures of the plants. They seized evidence. They arrested him on drug charges. And they brought him to trial. And during his trial, and we were involved with looking at language and talking with Ed's defense team about how we might be able to help to inform the jury during this trial. Right. Then we found out that the judge kept dismissing people, and the prosecuting attorney kept dismissing people from the jury pool if they had any agreement with Proposition 215, if they thought states had any rights against the federal government, if they thought any state had a right to make its own laws for the citizens of that state, if they thought that anyone had a right to use anything that hadn't been approved by the FDA.
So otherwise they were simply stacking the jury.
Sure, but then it gets worse, because then they told the defense team that because medical marijuana was not recognized as legitimate use of a forbidden plant or drug, since it was not recognized as having any medicinal value at all, they could not mention in the defense what Ed was doing and why.
Yeah, that does seem kind of odd, since the case is in California, and California passed it.
So not only does the jury not know that they have the right to find someone innocent if there's a crazy law that anybody with any sense would break, if they felt compelled to do so, because the government has no business making these laws in the first place. So they don't know that they can say no to bad laws. They don't know that they have the right to judge the law itself according to their conscience, but they're also not given all the facts in this case. So they don't even really know what's going on, and so they're confused. And they also, because of the instructions given to them by this federal judge, they feel rather intimidated, and they feel compelled to follow the law that the judge tells them is the law this fellow broke, and this is why he's being tried. And he obviously broke the law because he's not supposed to grow any marijuana plants. And look here, he grew some. So he's guilty, and you must find him guilty. And one of the jurors, after the trial was all over and some other discussions had taken place, which I'll discuss in a minute, but one of the jurors with whom I talked said, I was afraid that if I didn't follow the judge's instructions, and if I found this guy not guilty just because I didn't think he'd done anything so terrible, I was afraid they would put me in jail too.
So he was worried about being in contempt of the court then?
Yes, he was. He didn't know that he was an independent, free citizen of the United States, and that his primary role as a juror was to protect his fellow citizens from the tyranny of government and from the usurpation of the ability to perform on our rights, to act on our rights, to exercise our rights.
Right, as I understand it.
We take our rights away. As we know from our founding documents, they are unalienable. That means they can't be separated from us as human beings.
Right.
But the government can deny us the right to exercise those rights. They can't take away the rights from us. We have those as humans. But they can make it darn tough for us to exercise those rights. And that's what they were doing to Ed Rosenthal.
Well, I do, because I think the only thing that the judge can't really tell you to do is convict.
No, but they can make it so obvious that that's what they want you to do and think you should do, and will be very upset with you if you don't do. But if you're in a court of law that's run by a judge, and it's a government building, and it's a government law, and you're a law-abiding citizen who basically follows the speed limit and pays taxes and does all those good things that we're supposed to do to be responsible people, then you're going to try to be a responsible person while you're serving on a jury. And you may forget, and I think sometimes, I know they do because they've told me, sometimes jurors forget that they have someone's life in their hands.
Right, they do, and they've got to realize that juries, they have the right to simply vote their conscience and judge the law, whether it's fit or unfit.
They have the right, and it's not even so much a matter of judging the law, they certainly have a right to examine the merits of the law and judge the merits of the law, but they have a right to determine that this person simply hasn't done anything bad enough that they deserve to be punished. And I often tell people these days, if they don't bring in a body, or at least photos of a body, if they cannot produce victims willing to testify against the person, assuming that, that people are still alive and not a body, if there are no victims, where's the crime? And why is the government involved? Because isn't our government supposed to protect our person and our property against harm and seizure?
Well, they should, but I think when you're talking about the congressional actions and you're talking about state legislatures, a bumper sticker I once said, if you want fewer crime, outlaw fewer things.
Exactly.
And sometimes we have to look at those things we're trying to outlaw, and are they, or should they be outlawed? Are they victimless crimes, or is it something that we really need on the books?
And if it's a victimless crime, then how is it a crime?
That's right, it's a crime because the lawmakers passed it, and they said, look, there's a crime. And
William Penn was put on trial in 1670 on September the 5th, as a matter of fact. Or that was the day he was acquitted, actually. But when he was put on trial, the jurors thought about it, and they realized there were no victims. When John Peter Zinger was put on trial, the jury realized he was telling the truth.
Well, because I guess you could say the governor of New York, or the governor of New York Colony was actually a louse, and the people knew it. And
yeah, he was creating victims. He had victims. He'd been put on trial for, taking people's money and depriving them of the exercise of their rights and that sort of thing. There were victims who could have testified against him.
Now, do judges and attorneys know about or do they understand the process of jury nullification and the fact that jurors do have rights?
You know, it's interesting because sometimes I think it's not taught in law school anymore. And I'm not even sure people read the Constitution and understand what it's about, nor do they read the definition of a jury as it existed at the time the Constitution and the Bill of Rights were written. And I sometimes laugh and say, okay, so the prosecuting attorneys were asleep in law school when that class was going on, and they talked about, don't forget that the jury has the right to do this and do that. When our Constitution and our Bill of Rights were written, and I'd like to read something to you.
All right.
Daniel Webster wrote a dictionary because he wanted to preserve the language of the time so people would understand the definitions of the words used in creating our law. And I want to read you his definition of a jury. A jury is a number of freeholders selected in the manner prescribed by law, impaneled and sworn to inquire into and try any matter of fact and to declare the truth on the evidence given to them in a case. A petty jury consisting usually of 12 men, and now, of course, women are included,
right,
10 courts to try matters of fact in civil case causes and to decide both the law and the fact in criminal prosecutions. You want me to reread that? And to decide both the law and the fact in criminal prosecutions.
So that was
The decision of a petty jury is called a verdict.
So that basically went along with what the founding fathers
Sure.
had mentioned with their ideas of a trial by jury and
they didn't see the
Sixth
jury
Amendment.
as this little, sterilized and carefully washed group of people who would sit there and decide, well, we think that, John Doe did something wrong, and so we're going to find him guilty because we think he needs to be punished. They put juries into the Bill of Rights. They mentioned it 4 times in the Constitution and the Bill of Rights. You'll find juries discussed and cited. They put it in there because they knew there needed to be a strong mechanism for protecting the citizens of any country against a tyrannical government or a government bent on usurping the power of the people. And I don't know if I've ever written to you, but the Fiji Stationery has my favorite quote at the top of the page. But you probably know this quote if you've looked at our website, and we'll talk about that in a minute. And it's a quote that Thomas Jefferson wrote in 1789 when he was writing to someone about what a jury is and what it's supposed to do. Thomas Jefferson said, I consider trial by jury as the only anchor yet imagined by man by which a government can be held to the principles of its Constitution.
So if that's the case, then why do we have to go back in terms of state legislatures and pass this legislation that would actually allow the jurors the rights that they already have?
Well, for a long time, jurors in this country knew they had that right. They knew that they could sit down and think about a case and decide whether or not the law was correctly applied, whether or not the application of the law merited any punishment, if the law was in fact one that should be enforced. And they didn't have any doubts about their power and their right to make a decision based on their conscience. And in fact, maybe a couple quick quotes, but John Adams said, it is not only the juror's right, but his duty to find a verdict according to his own best understanding, judgment, and conscience, though in direct opposition to the directions of the court. That's pretty straightforward, isn't it?
It certainly is.
And there was a case in 1794 where Chief Justice John Jay, now remember, he was the first U.S. Supreme Court Justice, so he knew his law pretty well. He said, the jury has the right to judge both the law as well as the fact in controversy in any case. So jurors knew this for a long time. Nobody had to tell them. They knew this. But then, in 1895, there was a case that went to the Supreme Court called Sparf versus Hansen.
Right.
And there was a really bitter split in this decision by the Supreme Court. They said in this decision that the failure of the judge to remind the jurors of their powers was not a basis for mistrial or appeal, because all the jurors knew about it anyway, so nobody had to remind them. They knew they had the right to judge the facts of the case as well as the law and its application, and the merits of the law in this case.
Yeah, that kind of seems like where we're heading with the Miranda ruling these days, that the officers really don't have to read them their rights.
Well, we hope that that's going to stand. We hope that they will need to read them their rights.